welcome. Last fall, the Federal Trade Commission issued a policy statement purporting to provide guidance on the scope of its application of the unfair methods of competition standard in Section 5 of the FTC Act. The guidance is sweeping, abandoning the rule of reason and the consumer welfare standard, and asserting the authority of the FTC to declare unfair virtually any business practice that runs afoul of a, at best, nebulous two-part test. The substantive core of Section 5 is concerned with enforcement, authorizing the FTC to bring legal action if it determines that the conduct of a business constitutes an unfair method of competition or amounts to unfair and deceptive acts or practices. A separate but as yet untested question is whether Section 5, together with Section 6G, also authorizes the FTC to issue substantive antitrust rules. The agency's current majority thinks it does, but there are myriad reasons to be skeptical of such a broad interpretation of the FTC Act. And this brings me to my guest. I am thrilled to be joined by former FTC Commissioner Noah Phillips. Noah currently serves as the co-chair of the antitrust practice at legal powerhouse Cravath, where he advises clients on antitrust, data security, and privacy-related issues. Before that, Noah was a prolific and highly respected commissioner at the FTC, playing an integral role in precedent-setting antitrust, consumer protection, and privacy enforcement actions and regulatory matters. Earlier in his career, he served as chief counsel to a U.S. senator and clerked at the Fifth Circuit Court of Appeals. He earned his AB from Dartmouth and his JD from Stanford. Noah, thanks for joining me.
Mort, thanks for having me. It's great to be here with you and with SIAA and your members. I should caveat, I'm speaking for myself and not for the clients of Cravath or Cravath as an institution, but really great to be here with you.
Thank you. Your former colleagues have been clear that they see a role for the FTC as a rulemaker in the antitrust space. Chair Khan has framed it as a reactivation of the full set of authorities that Congress has granted the agency in her interpretation. In your article against antitrust regulation, you argue that the current FTC majority's position is wrong. What are the statutory arguments against FTC antitrust rulemaking authority, and what are the constitutional arguments against?
Sure. So I think it's best to start, as courts instruct us we have to, with the text of the statute. We can also look to some other evidence about legislative history and that sort of thing. In the article you mentioned, which I published right before I left the FTC, I looked very carefully at the text and the structure of the FTC Act to see whether it really suggested that there was substantive rulemaking power to regulate unfair methods of competition, and not just, as we see in Section 5, to bring cases to stop unfair methods of competition, which everybody agrees the FTC has authority to do. And the first thing you notice when you look at the statute, there are words that say that the FTC can make certain kinds of rules and regulations to effectuate its jurisdiction. That's not an exact quote, but that's basically what it says in 6G. But then you look at where 6G sits. 6G is a provision having to do with the classification of corporations. It sits within Section 6 more broadly, with one of its sister provisions, 6B, the most famous provision in Section 6, which allows the agency to conduct studies with effectively subpoena power of different aspects of the market, studies the agency is still conducting today. Section 6 reflects one of the two visions that Congress people had when they were contemplating setting up this new agency, the FTC, in 1914. There was one vision, which was an enforcement vision, and that's embodied in Section 5. Again, the provision that says unfair methods of competition aren't allowed, and here's how the agency can stop them. The other vision was basically a kind of congressional think tank. The agency was set up to have powers to investigate business conduct and to make recommendations to the courts, which is part of the statute, and to Congress, also part of the statute, on how they should proceed, also obviously informing the agency's enforcement mission. But two visions, one of an agency as an enforcer of law, and the other vision of an agency as sort of a student and a think tank, which, by the way, is somewhat similar to its historical antecedent, the Bureau of Corporations in the Department of Commerce. So this language shows up not in the section having to do with what's illegal, and not in the section having any kind of teeth, and I'll talk about that in a moment, but rather in the section about studying, looking at business conduct, and making reports, again, to Congress, to courts, and so forth, about the FTC's view of that conduct. That's a really odd place to stick broad regulatory power, in particular because it doesn't say anything about unfair methods of competition. So the other thing it doesn't talk about at all is any kind of penalty for violating the rules. And there's a really interesting article that goes through a lot of the early agency authorities that look like this, and speculates, or maybe argues is a better word for it, that when Congress wanted to give an agency the power to make rules, they would give it penalty authority. And really, when we think about rules and regulations, we often think about penalties associated with them. There's no penalty associated with a violation of this rulemaking power if it does exist. So this is a very odd place to put broad power. It's not backed up by penalties. Not a good suggestion, both in light of those facts and in light of the legislative history, that this is that substantive rulemaking power that the agency is claiming. Here's another thing. For about 50 years, from 1915, when the agency opened its doors, through the early 1960s, nobody thought the agency had this power. And in fact, right, there are agency statements and DOJ statements that reflect a view that the agency doesn't have substantive UMC rulemaking power. Over time, it would get power to make other kinds of rules, but there's no indication from the historical record until the early 60s, as far as I can tell, that even the agency thinks it has this power. So then what happens? And this gets us to sort of the rub of at least part of the legal issue. In the 1960s, the agency discovers this authority in its statute, and it starts making rules. Most of those rules aren't really competition rules. There's one that sort of looks like a competition rule involving men's and boys' tailored clothing and the relationships that the manufacturers have to the sellers, but the rule's never enforced. It's replaced with the Fred Meyer guides in the 90s. So we don't get a case on that, but we do get a case, a consumer protection case, in National Petroleum Refiners. And that's the legal precedent from the early 1970s that leads the agency today to argue it does have, in its view, clear authority to make the rules. So let's talk a little bit about National Petroleum Refiners. National Petroleum Refiners is an opinion from the DC Circuit, again in the early 1970s. Judge Bazelon is on the panel, Skelly Wright writes the opinion. It looks nothing like the opinions we see today. In sum and substance, what it says is, there's this language in the statute, and we have a congressional policy of helping agencies effectuate their authority by giving them rulemaking power. And so we'll look at the legislative history, not really what courts do today. And what do they find when they look at the legislative history? They find ambiguity. And there's a whole annex to the decision that goes through the legislative history. But what the court says is, given our policy of imbuing agencies with authority, whether they have it or not, we're going to take congressional ambiguity and give them rulemaking power, because that's how we approach it. Okay, that's the early 1970s. Fast forward to 2023. This is the world of West Virginia versus EPA, the world of the eviction ban, the world of the vaccine mandate. This is not how federal courts look at agency regulatory authority, and especially not so where the claim that the agency is making is very, very broad. And you need look no further than the president's executive order in July of 2021, laying out 7 different ideas of what the agency could do using its unfair method of competition rulemaking, a privacy rule, a non-compete ban, which we've already seen the agency start to proceed with, device issues, pay-for-delay settlements. Scarcely an industry isn't touched. But any way you slice it, they clearly are claiming broad authority. They're relying on a precedent that says the legislative history is ambiguous, the statutory authority is far from clear, in my view, indicated negatively. It's odd to think that courts today would approach this question the same way that the DC Circuit did in National Petroleum Refiners. And it's very odd to think that they would reach the same conclusion that that court did. So that's the statutory question and sort of the case law built out of the statutory question on which the agency is relying. There's a separate issue, though, that comes up, and it relates to the point that you were making about the broad scope that the agency sees in Section 5, right, in the underlying authority to bar unfair methods of competition on a case-by-case basis. So in the 1930s, the Supreme Court, that is, started putting teeth on a doctrine that has existed really since the 18th century, which is something called the non-delegation doctrine. It's the idea that at a certain point, Congress can't just give away its legislative authority, can't delegate that to an agency. It can give agencies rulemaking power, but there's a point at which, if the rulemaking power is so broad, it actually becomes a constitutional problem. And we've seen some lower courts start issuing delegation decisions really in the last year and a half, in part because now a majority of the Supreme Court has said on paper that they think revisiting the non-delegation doctrine is a good idea. Again, in the 1930s, the Supreme Court got a little active, but mostly since then, they haven't done a lot with the non-delegation doctrine. What did the court do in the 1930s, and how does it relate to what the FTC is trying to do today? I'm going to focus on a case called Schechter-Poultry, which is kind of the granddaddy non-delegation case. So Schechter-Poultry is an interesting fact pattern just because of the underlying facts, where there's a kosher butchery in Brooklyn, which I think still exists today, or at least the building still exists. And they are the object of an implementation of the National Industrial Recovery Act, the NIRA, which is one of the early New Deal cases. And they're complaining about regulations that are imposed upon them really by supporters of their competitors, and there's also sort of a suggestion of anti-Semitism. But in that case, the Supreme Court is looking at the NIRA, which allows President Roosevelt, that's FDR, to promulgate codes of fair competition. And the Supreme Court says, no, this is too much. This just isn't bounded. And so giving you the authority to do this, even though Congress clearly did it, is a violation of the non-delegation doctrine. So why is this relevant? Because the FTC Act says unfair methods of competition. And as you noted earlier, the FTC takes a very capacious view of what those are. So in 1935, you've got the Supreme Court saying you can't give the executive the power to promulgate codes of fair competition. And the FTC is asserting authority to make rules governing unfair methods of competition. Okay, so the FTC Act was passed in 1915. The decision in Schechter-Poultry is in 1935. They're clearly aware of it. And in fact, they talk about it. So the Supreme Court is looking at the FTC Act. And I think, you can read the decision for yourself, but what they are thinking of at the time is what they call a negative power, a power to stop conduct from happening. And they talk about the FTC's process in terms of it being on a case-by-case basis, an adjudication, all of which is consonant with how the FTC still works today in most matters, but critically, the entirety of what anyone in 1935 thinks the FTC can do, because at that point, no one thinks they have rulemaking authority. And so it's very interesting to think about how the modern Supreme Court, which is interested in coming back to these doctrines, would look at an assertion of power like this, with the authority what it is, as I said before, the agency's broad and capacious view of the power that it has, and also considering the fact that when this fact of the FTC Act was distinguished in 1935, no one thought the agency had this rulemaking power. There are delegation arguments made in cases, that have been before the court recently that have not ultimately been taken up. None of those statutes had language as close to Schechter-Poultry as this. I think the obverse is the right word to describe the relationship between unfair methods of competition and codes of fair competition, but clearly the concepts are related. So I think there's a statutory issue, which we talked about a few minutes ago. I think there's also a real non-delegation problem that the agency may have to grapple with if that question is called.
Thank you. That was a really, good, fulsome answer. And I think from SIA's perspective, we definitely agree that that there is no that there are statutory as well as constitutional issues with the arguments that the current FTC majority is making in favor of their rulemaking authority. But assuming for the sake of argument that the FTC does have substantive antitrust rulemaking authority, what would be the consequences for the agency as an institution of such an expanded and potentially highly partisan role?
Well, I think, the court's going to look at all of the fundamental legal questions in answering, whether they have rulemaking authority. Part of what the agency grapples with as well isn't just courts, but, like any institution within the government, it has some well of political capital, and it has to choose how to allocate that political capital. The bigger the agency goes, the more it has to spend that well, because sometimes things are very popular and you add to your political capital, but sometimes also there are costs. And so I think that, in deciding how to proceed, you always have to think about the law, but you also have to think about the perception of what you're doing and how that impacts really political response, which can impact funding, it can impact oversight, lots of things like that.
I agree. I completely agree. Never underestimate the importance of political capital and how you spend it or allocate it. Switching gears a little bit, there are a lot of other things besides rulemaking going on at the federal agencies. How does that impact the advice you give to your current clients?
I think we have to take into account whenever we're considering a proposed rule, what the likelihood is that it ultimately will be upheld, what the likelihood is that it will be changed moving forward. The non-compete rule, which is the only unfair methods of competition rulemaking thus far proposed, is the only one under that statutory rubric. But as I mentioned before, the agency has the ability to make a lot of different rules. And when we're giving advice, we obviously have to bake that in, where it looks like the agency may be going. Even before, though, a rule may get promulgated, companies may want to be thinking about some of the conduct in which they're engaging. And sometimes, especially if the conduct isn't particularly helpful to the company, it may be pretty easy to say, look, we're not sure this will happen, but you may want to take a look at your conduct, understand this is the position that the agency is taking, and think about the risk that the rulemaking reflects to you. And to be clear, even when the agency can't make a rule, sometimes it will have the ability nonetheless to bring a case. And so there may still be legal risk associated with the course of conduct, whether the agency has authority or not.
Thank you so much. I think that was a great note to end on. So thank you again, Noah Phillips. Really appreciate your time and your insights. It was great talking to you. Thanks for doing this.
Mort, thanks again for having me.